Welcome to North Carolina Child Support Services. To better understand intergovernmental cases, North Carolina Child Support Services created an overview of what an intergovernmental child support case is and what you can expect when your child support case needs a second child support agency to help your family. This video will discuss what an intergovernmental case is and give you answers to some common questions about how these cases are worked and how long the process takes. Questions such as, what is an intergovernmental child support case? What happens first? What are my responsibilities? What are the local agency's responsibilities? How long will this process take? What if I don't receive the child support? And how do I find agency contact information? What is an intergovernmental child support case? An intergovernmental child support case is opened when the family members do not live in the same state, territory, or tribal land, and one-state remedies or direct actions are not producing results. This means two or more child support agencies work together to establish, modify, and/or enforce child support orders for families in those situations. Your case may start out as an intergovernmental case, or it may become one when one of the parents moves out of North Carolina. The North Carolina Child Support Agency is the same agency that provides services for families that reside in North Carolina and will handle the intergovernmental cases too. If you are unsure if your case is considered an intergovernmental case, just ask your caseworker. Every situation is different. On the next few slides, we will define some common terms in intergovernmental cases, starting with UIFSA, the Uniform Interstate Family Support Act. This is the law that child support agencies must use when two states are working together. Custodial Parent, or CP, also called the obligee. This is the person, parent or guardian, with primary custody of the child who may receive the child support. Non-custodial parent, NCP, also called the obligor, the parent who does not have primary custody of the child and may be ordered to pay child support to the custodial parent. Initiating jurisdiction, the child support agency that sends an intergovernmental case to another jurisdiction to work the case. It may be a state, territory, or tribe. Responding jurisdiction, the child support agency that receives the intergovernmental case from the initiating jurisdiction. The responding jurisdiction uses their laws to establish orders and their procedures to enforce orders. This too may be a state, territory, or tribe. Petition, the packet of information and forms that the initiating jurisdiction sends to the responding jurisdiction to open the intergovernmental case. Arrearage, the amount of court-ordered child support that was not paid. Sometimes it's called back child support, unpaid support, or past due support. Petitioner, the person or entity seeking support in the intergovernmental case and who usually resides in the initiating jurisdiction. Respondent, the person from whom paternity and/or support is being pursued and who usually resides in the responding jurisdiction. Registering a foreign order is a legal action. If the responding jurisdiction is asked to modify or enforce an existing order from a different state or tribe, the responding jurisdiction may need to register that order in their own court, so that the court has the power to modify or enforce the order as if it were an order that the responding jurisdiction entered. So when you find out your case is an intergovernmental case, what happens first? The answer depends on what kind of case you have. There are three major types of intergovernmental cases: parentage and/or establishment cases, review and adjustment or modification cases, and lastly, enforcement cases. Let's look at each of these case types. The word paternity means to establish legal parents. Another term you might hear to describe this is establishing parentage. If the parents were not married at the time the child was born, or no one has signed an acknowledgement of parentage, or the court did not enter an order to establish parentage, then parentage may need to be established. Or in other words, the court needs to enter an order saying who the father or the second parent is. The mother that gave birth is considered a legal parent unless parental rights have been terminated. If parentage needs to be established in an intergovernmental case, the mother will need to fill out forms from the child support agency before the case can be sent to the responding jurisdiction. The responding jurisdiction needs your information about you, your children, the other parent, and your signature on these forms before they can get a new order. The responding jurisdiction will not take your case without these items. The North Carolina Child Support Office will provide you these forms. The responding jurisdiction may require genetic or DNA testing to prove parentage. An appointment will be set up for the mother, father, and the child or children to get tested in the city or town in which that person lives. Even if the mother is not available for testing, as long as the father and the child are tested, the genetic test can still determine biological parentage for the courts. If the mother is not available, there may be another person taking care of the child, like an aunt, uncle, or grandparent. Child support can still establish parentage, but it is very important that your North Carolina child support worker know those special circumstances so the proper action can be taken. After parentage is legally established, the court can order child support to be paid. Establishment cases are cases where a new order of child support needs to be set. Establishment of a child support order is usually done at the same time parentage is legally established, but it can be done later. Orders may be entered against mothers or fathers. Once parentage is legally established, the court or administrative agency of the responding jurisdiction will use the financial information of the family to figure out the correct amount of child support according to the laws and rules of the responding jurisdiction. There are intergovernmental forms that are very important for establishment cases, and there may be more documents that you will need to provide, like your paycheck stubs and proof of the cost of medical insurance and daycare expenses for the child. If you already have an order, but it has been at least 3 years since child support was figured, or there's been a change in the parent's incomes or in the expenses for the child, one or both parents may want the child support amount to be recalculated. This process is called a review and adjustment or a modification. If the parents do not live in the same jurisdiction, sometimes North Carolina can still review the case for modification, but sometimes an intergovernmental case may be needed to modify the case. North Carolina Child Support Services needs to know in which jurisdiction the last order was entered, where the parents live now, and which parent is requesting the review before they know whether North Carolina can do the modification or if an intergovernmental case is needed. If an intergovernmental case is needed, the parent who wants the review will need to fill out the forms from North Carolina Child Support Services and provide financial information like paycheck stubs and proof of expenses for medical insurance and daycare for the child. This would happen before the case can be sent to the responding jurisdiction. Did you know that child support agencies help both mothers and fathers start the review process and to modify child support orders? And after the review, the monthly child support may go up, it may go down, or the amount may not change. The last kind of case we will discuss is an enforcement case. If the parent who owes support is not paying as ordered and lives in a different jurisdiction, North Carolina Child Support Services may send the case to the jurisdiction where that parent lives or is receiving benefits. Usually, there are no forms for the parent or the party who receives support to sign. If the parent who owes support is paying child support directly to the family and it is not going through the child support agency, the parents must tell the child support worker about those payments, including the date they were paid, how they were paid, and the amount of support that was paid. When the parent who owes support is ordered to pay child support through the child support agency, but support is being paid directly to the family, it will cause problems for proving how much was paid and how much is still due. Child support should be paid as court ordered. You may wonder, what are your responsibilities for the child support case? If you are the respondent, here's how you can help your intergovernmental case be as successful as possible. Provide all the requested information to your caseworker. Respond to any request for information and return documents on or before the deadline. Update your child support agency with changes in your contact information, family situation, or financial situation. If you are the petitioner, here's how you can help your intergovernmental case be as successful as possible. Provide all the requested information to your North Carolina Child Support caseworker. Send in your special forms, information, and documents on or before the deadline. They do not have to be notarized, and you do not need to hire an attorney to represent you. Update your child support agency with changes in your contact information, family situation, or financial situation. This includes if your child goes into foster care, goes to live with someone else, or if you have a new baby born. Once the paperwork is filled out correctly and completely, North Carolina Child Support Services will get that process started as quickly as possible, and they will help the responding jurisdiction to start working on your case without having to request more information. If the information on the special forms is not correct in the opinion of the responding jurisdiction, then the North Carolina Child Support Services caseworker will have to keep working with you to get it right, which may slow the process. Lastly, be sure to tell your North Carolina Child Support caseworker if the responding jurisdiction makes contact with you, or if you would like to participate in hearings scheduled by the responding jurisdiction. You will not have to travel to the court hearing in the responding jurisdiction. Under UIFSA, the responding jurisdiction's court cannot force you to appear in person. Your North Carolina Child Support Services caseworker will notify you if the responding jurisdiction is requesting that you testify. Also, if you want to be present, you should tell your caseworker when you return the forms. To participate, the responding jurisdiction will set up a special telephone call or virtual meeting, and you can appear from home, work, or your local child support office. You may wonder who does the work on intergovernmental cases. The answer to that question is both jurisdictions. When North Carolina is the initiating jurisdiction, the worker in North Carolina will help you the most. Even when the case is an intergovernmental case, North Carolina Child Support Services keeps helping you. This agency will prepare the intergovernmental referral and send it to the responding jurisdiction, answer your questions about the case, monitor the case to make sure the responding jurisdiction receives the paperwork and assigns it to an office. The North Carolina Child Support caseworker will work with the caseworker in the responding jurisdiction to make sure they have everything they need to go forward with your case. Your caseworker will contact the responding jurisdiction for updates and pass that information to you. You will also receive copies of all important documents your caseworker receives, including the new court order. The North Carolina Child Support Agency will send you the child support when it is paid on your case. You will talk to your caseworker about direct deposit options for payments. The responding jurisdiction is helping you by filing your action in their jurisdiction and handling your case like they do their own cases. The responding jurisdiction will use their jurisdiction's laws and formula for calculating child support. It may be very different than what would have been ordered if the case were filed in North Carolina. For parentage and new support orders, the other jurisdiction's laws govern that order for everything, including at what age the child is no longer eligible to receive support. However, for a modification, the other state's jurisdiction's laws do not modify everything. Mainly, they modify the amount of support and the payment date. The jurisdiction laws in your first order still control what age the child is no longer eligible to receive support. The child support agency in the responding jurisdiction will work and communicate with your local child support caseworker to get orders entered and child support payments made. If you are the respondent, you should always contact your child support worker in your state. If you call the North Carolina agency directly, we will tell you to call your in-state caseworker. If you are a petitioner, you should always contact your child support worker here in North Carolina with your questions. If the responding jurisdiction contacts you and wants information so they can figure out child support, or if they want you to appear at court, please contact your caseworker here in North Carolina. If the responding jurisdiction sends you letters or the order, please call your caseworker in North Carolina to make sure everyone has the same information. If you call the responding jurisdiction, they should tell you to call your North Carolina Child Support Services caseworker. Let's now discuss the timeline of an intergovernmental case, or how long will this process take? Intergovernmental cases are more complicated, and more than one child support agency is involved. It's still the best way to get the child support you need when the parents do not live in the same jurisdiction and the state is not able to work directly with the other parent. Some reasons for the extra time are that the referral packets require special documents that can be hard to obtain, such as paternity documents, court orders, or payment histories. And the referral has to go to at least 2 offices before a caseworker there can start working the case. If you need to get an order established, there are several factors that affect how long it takes. In both parentage and modification cases, the paperwork will have to be served on the other parent, and you will have to get on the court calendar or docket. Depending upon the other parent and the size of the caseload in the courts, both kinds of actions can take a while, just like if you were going to court here in North Carolina. The biggest reasons to remember are if the other parent does not cooperate, or if the responding jurisdiction must take it to court. It could affect the timeline. If the responding jurisdiction uses administrative processes, meaning they do not need judges or courts to enter orders, the case may go fairly quickly. In parentage cases, if the court orders genetic testing, the normal range is 6 to 18 months to get parentage and a support order after the referral has been sent. For modification cases, the normal range is 6 to 12 months to get a modification of an order after the referral is sent. With a new order, the responding jurisdiction will start enforcing the order, and if the other parent is working, payment should start fairly quickly. If the parent who owes support is paying, you should receive child support payments via direct deposit or debit card within 4 days after the payment is made in the responding jurisdiction. The payment will be forwarded to North Carolina's Child Support Agency, and both states will keep a record of payments due and received. At least once per year, North Carolina will get payment accounting records from the responding jurisdiction to make sure all payments have been given credit and that balances match in both jurisdictions. You may ask, what if I don't get the child support? Both states will be working to enforce the order. In the initiating jurisdiction, North Carolina Child Support Services will keep working your case. North Carolina Child Support will monitor the case to find employment or other income for the parent who owes the support, and either take actions to get the payment started again or ask the responding jurisdiction to enforce the order there. In the responding jurisdiction, if the initiating jurisdiction requests assistance to enforce the case, the responding jurisdiction will monitor your case for employment or income for the other parent and will send income withholding orders to the employer to pay the child support if applicable. However, in intergovernmental cases, if the parent who owes support is not cooperating, many times the case must go to court in the responding jurisdiction to take one or both of these legal actions, either a registration of a foreign order and/or civil contempt actions. The legal actions could take several months before the other parent appears before the judge. The success of this will depend upon the parent who owes support's ability and willingness to pay. We hope this video has provided you with useful information. If you have questions, please visit our website at www.ncchildsupport.com for more information about child support cases and the North Carolina Child Support Program. You may also call toll-free to 1-800-992-9457 to update your contact information or case information. You may also leave a message for your child support worker by dialing this number. Please stay in contact with the North Carolina Child Support Services Agency so we can work together to make the best decisions for your child support case. Thank you.